We do acknowledge receipt of a copy of the indictment. We would waive any defects, time, place, manner, service. We would waive the reading of the statute, penalties, and right. We are tendering a plea of not guilty to all counts in the indictment. Furthermore, Your Honor, we are tendering a plea of not guilty by reason of insanity, and we have already filed a written plea indicating a plea of not guilty by reason of insanity. Your Honor, counsel is requesting that evaluation occur. We would ask that that occur at the Court Diagnostic and Treatment Center, both for competency and for criminal responsibility. I have received partial Rule 16 discovery. I will sign an entry indicating the same. As to the issue of bond, we would defer to the court's discretion.
Record should reflect that Assistant Prosecuting Attorney Alex Treece is present on behalf of the state of Ohio. Court has received, Mr. Sass, you filed this morning at 10:53 the plea of not guilty by reason of insanity, a motion for competency evaluation pursuant to 2945.37 and 2945.371 of the revised code. We will have a brief pretrial conference at 9 a.m. on June 13th, 2016. It's my understanding the bond has previously been established in the Findlay Municipal Court. Is that correct, Mr. Treece?
That's correct, at $1 million.
Mr. Treece, any thoughts on the issue of bond?
I would ask that the court maintain that $1 million bond. I'd first ask that the court consider the nature of this offense. This is an aggravated murder, subjecting Mr. Drain to a potential life imprisonment. Second, I'd ask that the court consider there's a retaliation aspect here as well. He was indicted by the grand jury on that offense, and that also raises concerns from the state. Second, I'd ask that the court consider Mr. Drain's criminal history, which does include prior offenses of violence and offenses outside the state of Ohio and Florida. And in fact, Mr. Drain was only released 20 days from his Florida prison when he was alleged to have committed the 16 CR 97 felonious assault case, and then released only a matter of days before the alleged commission of the offenses before the court. So we have now an established history of how he may conduct himself while under supervision. So given the nature of the offense, the violent criminal history, and the past performance, I'd ask that the court maintain that $1 million bond.
Okay, we'll continue the bond that was previously established in the Findlay Municipal Court after the judge's probable cause review of preliminary matters brought to the judge's attention. The court also is well aware of Rule 46 of the Ohio Rules of Criminal Procedure, which allows the court to consider a wide range of factors concerning prior record, concerning nature of the criminal activity, the charge, concerning the other pending charge, state of Florida, and all those matters. So the bond will be continued as established in the Findlay Municipal Court. There will be an additional hearing should someone come forward to post the bond on behalf of the defendant. Mr. Sass, I trust you have talked to Mr. Drain about the fact that the plea of not guilty by reason of insanity, and the motion for the competency evaluation extends the defendant's constitutional and statutory right to a speedy trial until those issues are resolved.
That is correct, Your Honor.
Mr. Drain, any questions today?
No.
Okay. Anything else, Mr. Treece, Mr. Sass?
No, thank you.
No, Your Honor.
It will be before the court then the 13th of June at 9 o'clock a.m. We will